costs is where an order is made in interlocutory proceedings. The party in whose favor is made shall be entitled to his cost respect of those proceedings whatever the outcome of the cause or matter in which the proceedings arise. For instances, parties may want to make amendments to their cause papers or file a separate interlocutory application for security for costs, or apply for court to allow it to gather evidence by way of discovery and inspection against the opposing parties. These are merely ancillary matters which are not directly connected to the main dispute between the parties, but are necessary to be resolved in order to ensure the efficient progressing of the case.
Order 59 Rule 20 in Magistrates Court, the sum must not exceed 2,500 Malaysian ringgit. In Sessions Court, the sum must not exceed 8,000 Malaysian ringgit. Order 59 Rule 21 The amount of cost payable upon the conclusion of any interlocutory application, other than those falling within the ambit of Rule 22 shall be at the discretion of the court, but in fixing the amount of costs, the court shall have regard, inter alia, to the factors set out in Rule 16.
Circumstances where interlocutory proceedings takes place. Number 1. Costs. In any event, the party in favor shall be entitled for the costs only after the conclusion of the proceeding. Number 2. Costs reserved. The party in which an order for costs is made shall be entitled to his costs to the end of the proceeding, unless court order otherwise. Number 3. Cost. Here and below, the party in favor shall be entitled for both costs of the order made as well as the costs of the same proceedings in any other court. Number 4. Costs. In the cause, the party in favor of the order made shall be entitled to his costs at the conclusion of the cause or proceeding. Number 5. Cost paid forwardth. Either party to a proceeding shall be entitled to the costs of the order made by the court regardless that the cause or matter has yet to be tried. Number 6. Cost thrown away. The proceeding has been set aside or ineffective. The party in favor of the situation, defendant, respondent, shall be entitled to his costs. Lastly, number 7. Plaintiffs and or defendants' costs in cause. Plaintiff and defendant shall be entitled for their costs as the court order in its judgment in the cause of the proceeding.
Number 1. The deposit of monies with a court or the provision of some other acceptable form of security to meet the possibility that the party ordered to provide the security will fail in the proceedings and will be unable to pay costs so ordered as per case Risky v. Computer Manufacture and Design Proprietary Limited, 1982, NSW GLUP4043. Number 2. The objective for the guarantee for costs is for the appeal matter. Number 3. The High Court possesses the powers to order security for costs. Number 4. Since defendant is the one who apply for security for costs, defendant has legal burden to justify their application, not plaintiff. Number 5. In certain cases defendant may require plaintiff to give security for costs before proceeding, to prevent defendant from being harassed with the trial. Factors considered in granting guarantee for costs. Number 1. Plaintiff's whereabout address is not stated, incorrect or changed, in writ or OS ordering proceedings. Plaintiff is an ordinary resident, out of jurisdiction. Number 2. Nominal plaintiff suing for benefit of some other person and there is reason to believe that he will be unable to pay the costs of defendant. Number 3. The urgency of application whether defendant has delayed in making the application for security. Southern Cross Exploration and LV Fire and All Risks Insurance Company Limited. Number 4. Plaintiff's intention whether plaintiff's claim is bona fide and has reasonable prospects of success. Sir Lindsay Parkinson & Co. Limited v. Triplan Limited. Number 5. Plaintiff's lack of funds the financial position/status wound up or bankrupt, equal unable to pay costs due to conduct of defendant. Number 6. Genuity of plaintiff whether the plaintiff's proceedings are merely a defense against self-help measures taken by a defendant. Interwest Ltd v. Tricontinental Corp Limited. Number 7. Effect to proceeding if making of the order would unduly stultify plaintiff's ability to pursue the proceedings. MA Productions Proprietary Limited v All Star Television Proprietary Limited.